Hello, I'm Gina Jurva, attorney and manager of thought leadership with the Thomson Reuters Legal Executive Institute in San Francisco. Joining me today is Gabe Hidalgo. He is a managing director at K2Intelligence, where he works with financial institutions on cutting-edge areas like the emerging cannabis markets, cryptocurrency, fintech, and more. Gabe helps his clients navigate and mitigate Bank Secrecy Act and anti-money laundering compliance risks, or BSA/AML compliance risks. Welcome, Gabe. It's a pleasure to have you here. Let's talk about weed. Marijuana is a growing and lucrative business. There's 33 states and the District of Columbia that have legalized cannabis or marijuana in some form, whether we're talking medical marijuana or recreational marijuana. So let's say I have a cannabis business in California. And I, like any other business that I would open, would want banking services of some sort. So a checking account, some place to deposit funds, pay my employees, for example.
The issue is really not so much on the state level, but more on the federal level. THC, the ingredient that's active in marijuana, and actually the marijuana plant is still illegal pursuant to the federal level law. So what you have is basically the ability to provide these products and services, whether it's hemp or marijuana or CBD at the state level versus the prohibition at the federal level. So what happens is, if you are a legal licensed cannabis-related business in California, your options for receiving banking services are limited. It's going to be limited locally, and not only that, but then there are certain banks that have a very conservative risk profile, and they would not want to bank cannabis-related businesses.
Hemp, CBD, and marijuana. What is the difference between those three for banking purposes?
From a banking perspective, the cannabis family has several different strains of the plant. Industrial hemp is a plant from the cannabis family that has less than 0.3 of 1% THC, which is the psychoactive ingredient that gets people high. So you can have a plant determined to be industrial hemp, where you can produce CBD oils and all these other products from it. But if you, for example, try to smoke something that's created from industrial hemp, it's not going to get you high.
Okay.
So you can't roll up a piece of paper that's made of hemp and get high that way. You would actually need the THC formulated cannabis to actually receive that effect.
In the news, people hear a lot of different things about it, that hemp is actually become legalized. Is
Yes.
that correct?
At the federal level, in 2018, they passed the Farm Bill. And the Farm Bill actually took industrial hemp off of the controlled substances schedule, whereas previously it had been grouped together with marijuana. But very early on in the US, we've used industrial hemp for many things: ropes, sails, paper, all sorts of things. So since 1970, it was actually included with marijuana, and now it's not. So what that does is it allows people who farm industrial hemp to actually grow their crops and not have to worry that they're going to be violating federal law. And in fact, it opens up a huge marketplace for products that are built on industrial hemp. You have shampoos and toothbrushes and all sorts of different things that you can now offer, as long as you're licensed appropriately at the state level. Just because it's legal doesn't mean that anyone can go out there and grow industrial hemp. It still needs to be tested to make sure that it's falling below the 0.3 of 1% THC content to be classified as industrial hemp. But in fact, the 2018 Farm Bill has taken away the federal restrictions for growing industrial hemp and selling those products as long as it's legal at the state level.
Can you explain some of the challenges around having a cash-intensive business like this?
So let's say you opened up a dispensary in your name, and you got all the appropriate licenses and everything, and you had an operational account from a bank in California. The issue really becomes, in the United States, we have two main ways of paying for things. You can pay in cash, or you can use an electronic format such as a credit card. The credit card networks do not allow transactions because of the federal prohibitions on servicing marijuana companies. They don't allow. So Visa, MasterCard, Discover, Amex, they will not process any transactions that are from companies or merchants that provide, for example, marijuana. So what happens is, because you've eliminated one aspect of the payment ecosystem, everything comes in through cash. So dispensaries are really caught in the middle of trying to service their customers, but also trying to get that money into a bank. There are people who track the movements of these duffel bags full of cash or suitcases full of cash, and they end up getting robbed. Insurance premiums are a lot more expensive because the insurance companies know that there's a higher risk in the transportation and the storage of the cash. In addition to that, a lot of cannabis-related businesses pay their taxes in cash. They'll walk up to the county tax assessor's office with a suitcase and say, here's my payment for this year in regards to all the tax that they owe. Some of the bank branches aren't close by, so let's say it's more than 10, 15 miles.
Sure.
Now you're driving on the interstate with all this cash. You can be held up either at the point of sale, you can be held up on your way to the bank, or even at the bank once you arrive with the bags. They know what's in those bags. But in reality, cash is king when it comes to this business, and you can't get around it, at least not yet.
The BSA, and when I say BSA, Bank Secrecy Act, and anti-money laundering perspective, when we're talking about trying to stop illicit funds from flowing into our financial institutions, wouldn't this actually run counter to that?
So when you have basically a high frequency cash business, like a dispensary, there is an opportunity to intermingle those funds with illicit funds. So for example, if I decided to try and legalize the business of drug selling, and I was already dealing in illicit flows of marijuana, and I had never been caught or arrested, whenever I apply for my license and they do the background checks, they'll see that I have no criminal record, I've never been accused or anything like that. I can then set up my dispensary legally, legitimately at whatever location, and then I could take some of my illicit flows that I would still sell on the side and introduce that into the flow of funds for my legitimate business. And a lot of banks, if they're not properly set up with their compliance programs, they won't notice the uptick in deposits. And then what happens is that it creates an illicit flow into the monetary flow for that bank without them knowing.
Any guidance that's currently in place right now for banks to follow if they are interested in banking cannabis? Because there are some banks that actually do. I know we at Thomson Reuters have spoken to them. So what guidance do we have out there?
So approximately nationwide, we have about 60 institutions that do bank cannabis in some form or another. Initially, we received the Cole memo from the Department of Justice, which set out 8 priorities that the government is looking to reduce or prevent from marijuana activity. That Cole memo was rescinded by Attorney General Sessions. However, FinCEN had put out shortly thereafter a guidance to banks on how to properly bank marijuana-related businesses, which now we refer to as cannabis-related businesses, in pursuit of meeting BSA compliance or anti-money laundering compliance. And that included 23 additional red flags. It included some best practices and some things that they would expect a bank who decides to bank cannabis-related businesses to do. In addition to that, it also required the filing of 3 different types of suspicious activity reports, which are specific reports that are required by the government from banks or financial institutions to report potentially suspicious activity. The first being a limited SAR, which is basically you're reporting on any type of activity that cannabis-related business does with your bank, regardless of whether they violate one of the 8 priorities that were listed within the Cole memo, or there's a suspicion of illicit activity occurring. Then there's the priority SAR, which is basically saying, I believe that this particular entity or person is violating one of the 8 priorities in connection with the Cole memo, or is participating in illicit activities that led up to this report. And then finally, there's the termination SAR, which is basically saying, not only do I believe that there is an illicit activity occurring here in some form or another, whether it's a violation of one of the 8 Cole memo priorities or some other illicit activity, but we are also terminating the relationship. All that was laid out within the FinCEN guidance of 2014. Now, the rescission from the Attorney General's session memo in 2018 rescinded the Cole memo, but did not rescind the FinCEN guidance, so that's still in effect. And banks can look at that as part of the toolbox, I would say, for compliance.
When you talk about SARs, just to further explain, so for a suspicious activity report, that is something that banks file when they believe that it's a document they file that goes to law enforcement when they believe that something is suspicious. Yes. They don't know for fact, but they believe there's something suspicious, and then that goes to law enforcement. And then what does law enforcement do with it from there?
So whether it's a bank or a money service business, there's a lot of financial institutions that have to report suspicious activity. Basically what happens is there's a narrative, there's a whole bunch of descriptions that occur in regards to the underlying activity that financial institutions find potentially suspicious because none of the financial institutions are deputized. So this is not a statement of fact, it's a statement of belief and suspicion. That goes into the FinCEN database, and then law enforcement uses that FinCEN database to data mine potential leads in either ongoing investigations or newly discovered illicit activity. And then they piece it together from many different sources to create whatever the case is going to be.
What advice do you give to banks who are or financial institutions who are looking to get into the cannabis business? It's a lucrative business. We keep hearing about more and more businesses opening up. More states are legalizing it. What advice would you give? Just some basic guidelines on what you would tell.
Sure. Before I think they even start to consider whether or not they want to enter this field of providing services to cannabis-related businesses, they really need to understand how much work it's going to take. There's all these SAR requirements that are now attached to that. There's an enhanced monitoring requirement because you have to look at every single transaction that cannabis-related business or businesses will be doing on your platform. So before anything else, we always counsel our clients to get a handle as to, is your compliance system as it currently is set up meeting its current obligations, meaning you don't have backlogs, there's no alerts that are more than 30 days old, you haven't had exam results from a regulatory agency that says your compliance program needs help. You're going to have to build capacity because this is going to be you're going to need a lot of compliance resource behind it. So we always say, before you do anything else, understand where your compliance program is currently. If you need help, so be it. We can help you kind of build that up, but you have to be okay with where you are. You can't be starting at below okay and then add this on because you're only going to burden your compliance department further. Outside of that, we always also ask our clients whether or not they've standardized a lot of the SAR formation. A lot of times what happens is we visit clients and they've decided that they allow their investigators a broad swath of options in regards to creating narratives and all these other things that should in reality be standardized so that you have a standard level of completeness, that all the required narrative information is in there, all those things. So we help them set up templates and other things to standardize that process, which helps them in efficiency, helps them make sure that the quality of the SAR is there. In addition to that, they also have to make sure that the transaction monitoring software, whatever the platform is up to snuff because they will be monitoring a lot more traffic. There's going to be a lot more cash deposits, and there's going to be movement of that cash once it hits the account to pay all different vendors that the cannabis-related business relies on. So therefore, you probably need a better system than you currently have. You probably need a little bit more manpower to handle all the SARs. It's doable, but I think at the very outset of when you're making this decision, you have to take into account your compliance requirements and build that into your pricing model so that later on what looks to be profitable ends up not being profitable because you fail to account for your compliance costs. So we asked that they do all that before they open their doors to these businesses.
Do you think at some point that the laws are going to change? There's federal legislation out there that's working its way through the House. It passed the House, the Safe Banking Act. What is your outlook as we're moving into 2020 and we have an election coming up? Like, how optimistic are you that something like the Safe Banking Act would pass?
So the Safe Banking Act recently passed in the House in September of this year. Getting through the Senate is going to be a completely different thing because I think it's does not have as much traction as it did in the House. Whether or not it passes in 2020, I don't think it will, or at least I don't think it will be brought up for a vote. You have a critical election year. I don't think that they want to vote on something that is as controversial as this act would be. I'm a very optimistic person when it comes to this area. I don't really see that there's going to be a changing of the tides. We already have 33 different states that in one way or another have already approved this. The District of Columbia has already approved this. States see this as a potential source of new revenue when they see their federal revenue being reduced on a year-to-year basis. So overall, I think over time, the vast majority of the states will approve this. And as you have all these states approving it, there's going to be a lot more pressure on the federal government to do something to standardize the law across the land. And there definitely will be probably a revisiting of the scheduling of marijuana as a Scheduled I drug, but all that takes time. My best guess is probably by 2030, we would see a federal kind of relaxation on marijuana from a descheduling perspective, because you have to move it off of the schedule as Schedule 1 drug into something else for it to really take hold on a federal level from a legality standpoint. But that all requires, for example, we signed on to a treaty that requires us to label marijuana as a Schedule 1 drug, an international treaty, which means that now we have to talk with our partners and say, hey, is there any way that we can adjust the treaty requirements to relax that from a Schedule 1 to something else? You have to have support in both houses of the legislature. Right now we have the House, but we don't have the Senate. Right. And you have to have a president who is more likely to sign it, so that you don't have to overcome his vote or his veto with a 2/3 vote. I can see that happening by 2030. I think by then, I would say 48 to 49 states would have approved it in some way or another, and then it'll be up to the federal government to say, hey, you know what, we're going to standardize the law for the nation and not have 49 different laws to kind of license this thing. And I think from a taxable base, there's going to be so much pressure to get this thing done to create additional taxable streams for all the states that are not receiving federal income in the way that they used to in the past. So as a prediction, I would say by 2030, but that's, again, that's just how the government works. It takes a long time.
Sure. Thank you, Gabe, so much for joining us today, and thank you for your insights. It's been a pleasure.
Thank you.
And thanks to all of you for watching. If you want to learn more about anti-money laundering, financial crimes, and cannabis banking, visit legalexecutiveinstitute.com and click on Risk and Compliance. You can also follow me on LinkedIn and Twitter, and check the related sites listed on the screen. Thank you.